Good morning, everyone. My name is Shreya Shivakumar. I'm a student of political science at Barnard College of Columbia University, and today I will be speaking on WHOIS data and post-GDPR domain privacy. I'm very honored to be here as a participant in the NextGen ICANN82 program alongside my fellow participants. Thank you for this opportunity once again. In the early days of the internet, privacy and anonymity signaled potential danger. People took pause when they didn't know what was happening or who was on the other side of their screen. Today, in 2025, the popular discourse on privacy has shifted considerably in a positive direction. Now, privacy is viewed as an essential right, even backed by law, by legal instruments in both in the US and internationally. With this conflicting interests and values, how do we strike a balance between upholding privacy rights and protecting the public from harm on the internet? The WHOIS debate illustrates this paradox perfectly. WHOIS is shorthand for who is responsible for this domain name. WHOIS is a service that asks and retrieves information about the registration of a domain name or Internet Protocol or IP address. When an individual registers a domain name or IP address, he or she is required to provide generic top-level domain or GTLD registration data. Beginning in the 1980s, domain registrars were required to provide public access to their registrants' WHOIS data. The information was made publicly available and updated regularly in the WHOIS database. The database stored WHOIS records and details about domain ownership, contact information, and registration dates. One could perform a WHOIS lookup to retrieve the GTLD registration data for domain names. A thin WHOIS lookup would provide basic data associated with the domain name, while a thick WHOIS lookup contained detailed information about the registrants and the contacts associated with the domain name. Some privacy advocates say that publicly available WHOIS data poses privacy concerns because users do not give affirmative consent to publish their information online. WHOIS records provide a wealth of information that can help identify and contact owners of specific websites. This is useful for law enforcement, particularly, and other interests who have a stake in ensuring the safety of the internet. Others claim that the value of WHOIS data for preventing online harms overrides these individual privacy interests. In fact, WHOIS data has proven instrumental in multiple cybercrime investigations, in identifying violations of IP infringement laws, and even stopping online exploitation of children on the internet. Multiple governments have recognized this. For example, the US Chamber of Commerce, after the passage of GDPR, stated that, quote, if access to the database is eliminated, there will be a significant rise in cyber attacks and fraudulent online activity without any ability for law enforcement, cyber researchers, companies, or consumers to respond or remedy, end quote. Cybersecurity professionals in the private sector also use WHOIS data to identify and protect their clients from malicious domains that conduct spamming and scamming activities on the internet. Using the contact information of domain owners, they block or delay activity coming from domains associated with individuals who send spam messages. Undoubtedly, the value of WHOIS data for identifying and preventing crime on the internet cannot be overstated. In this WHOIS debate, there are a variety of diverse stakeholders. One group are domain name companies. These domain name companies often provide services for their clients where they can ensure the domain privacy for an additional fee or include it free of cost with their domain registration. Second group is privacy rights organizations who have advocated for domain privacy for many years, saying that affirmative consent is required for this sensitive information to be published on the internet. Lastly is law enforcement. As I mentioned before, WHOIS data has helped identify the perpetrators of cybercrimes and stop malicious domain activities, and law enforcement is interested in having access to this data in a timely and accurate manner. The GDPR, or General Data Protection Regulation, is a European data protection regulation that went into effect on May 25, 2018. It changed the way that WHOIS data was stored and made accessible to the public. GDPR protects the data privacy of anyone within EU borders, a citizen or otherwise. The GDPR applies to any organization that processes the personal data of EU residents, regardless of its location. The GDPR necessitated wide-scale changes to the pre-existing system of data collection and storage for WHOIS data. After the GDPR was passed, it required some changes that restricted access to WHOIS data that was previously made accessible via the WHOIS database. After GDPR, there were multiple reports of cybercrime investigations that made it difficult to identify the attack source, an increase in malicious online activity, and a longer timeline to identify and stop attacks. ICANN was instrumental in creating policy to respond to these wide-scale changes that GDPR caused. The temporary specification restricted the availability of WHOIS data to individuals with a legitimate and proportionate purpose. 18, the ICANN board adopted the temporary specification, a policy designed to guide domain registrars to follow ICANN's requirements and policies while remaining in compliance with the GDPR. Under the temporary specification, registrars were allowed to collect registration data from domain owners, but could not make it publicly available in the WHOIS database. Instead, it restricted most personal data to certain authorized parties, only those with a legitimate and proportionate purpose. This included law enforcement and those with interests related to rights protection. These individuals could request access to WHOIS data through registrars and registry operators. Temporary specification mandated that registrars put up a generic email address or an online contact form to allow for contact with the registrant in case further data was needed. ICANN mandated that the temporary specification be implemented where required by the GDPR. In other words, personal information from domain registration data from non-EU countries could still be made available via the WHOIS lookup. This policy was intended to be temporary, and to remain in compliance with GDPR in the long term, ICANN envisioned a tiered access model that would restrict access to GTLD registration data to pre-authorized parties with legitimate interest. Next slide, please. Today, we have RDAP. In 2019, ICANN began a multi-step process to phase out WHOIS and transition to a long-term system to modernize domain registration data. As of January 28, 2025, the WHOIS system has been replaced with the Registration Data Access Protocol, or RDAP. The main advantages of RDAP are its improved security. RDAP allowed for tiered access, enabling registrars to disclose personal information only to authorized parties, such as those with law enforcement interests. RDAP also controls the extent of data access based on user categories. Additional benefits of RDAP are that it provides multilingual support and presents registration data in a standardized and accessible format. Any user on the internet can look up registration data using ICANN's registration data lookup tool available online. Next slide, please. There are many challenges and opportunities for policymaking related to WHOIS data in the future. One major challenge is the fragmentation of privacy laws across different countries. Another challenge is maintaining the accuracy and availability of WHOIS data on the internet so that the appropriate parties can get timely and appropriate access to them. There are also many opportunities. For example, WHOIS and GDPR are an evolving debate and policy challenge involving lawyers, policy experts, domain registrars, and other interests. The policymaking on this issue is a work in progress, but it represents the best of ICANN's multi-stakeholder model, generating a productive type of friction that helps us go towards a more positive and outlook on the future of the internet. As data privacy regulations evolve and technology advances, ICANN will be instrumental in striking a balance with policies that ensure the availability, access, and accuracy of WHOIS data while maintaining respect for individual privacy rights. Thank you so much.
Thank you, Shreya. Great job. Any questions for Shreya in the audience? Naveed, please.
Yeah, this is Naveed. I just need some clarification on what kind of features this RDAP offers over what WHOIS could not have presented. So what kind of improvements you see in those aspects going forward as people are adopting it over and over again, and ICANN made it mandatory for registries and registrars, basically contractual parties, to comply with it. What kind of improvements you foresee in future?
Yes, thank you for your question. The main advantages of RDAP over the prior WHOIS system is that it allows domain registrars to remain in compliance with GDPR, and it restricts access to WHOIS data based on people with prior authorized interests and authorization. This is also a service that's accessible to anyone. I have personally tried RDAP and used it, and I found that I'm unable to find a domain information for domains located in the UK because it's covered by GDPR, but I can do so for US-based domains since we are not covered by GDPR. So the main advantage I would say of RDAP is that it complies with the current state of data privacy regulations in the world. And for future improvements to RDAP, I would say it's just maintaining the integrity of the database and the accuracy of the information, ensuring that there's timely access to law enforcement interests and other authorized parties that need this information, while continuing to comply with the evolving data privacy regulations.
Thank you, Shreya. Before we take questions in the audience, we have a remote question.
And we have a question from Abraham. Abraham Selby, please unmute yourself and ask your question.
All right, thank you very much, Siranus. Thank you for the presentation on the domain privacy aspects. This is something that I'm very interested in. I'm Abraham Selby, and ICANN79 fellow and from Ghana. I am much interested in the policy aspect because when we check about the domain privacy registration, especially on the WHOIS, we see that some domain registry organizations accommodate a section whereby you can pay to protect your privacy. Some other hosting organizations also have waived that kind of payment, then they can secure it for you in a way. My question is that since you are doing this, do you have a future plan to research how ICANN can collaborate with such policies organization whereby in terms of registering a domain name, like or buying a domain online, it comes without protection automatically so that people's information will not be shared online, because you can buy the domain and you can choose on some hostings to protect the privacy by paying. So if someone don't have the money to pay or someone doesn't pay, meaning that the information is on, and this is causing a lot of relationship between the host provider and the users because people get their details everywhere online, and there's a cross-border data protection talking about GDPR, then also in African context. So how can your future research or this implementation also link with what ICANN can do to help us to alleviate that kind of financial barrier between users and the registrant? Thank you.
Thank you for your question, Abraham. What you said was absolutely correct. It describes the interests of domain registrars and registrants in the WHOIS debate. There are some domain services. I believe Namecheap allows a free of cost option where users can choose to hide their WHOIS information for privacy reasons, and other services offer the same privacy option for a paid supplemental fee as well. As far as making this more affordable and accessible to those who want this service, I believe that would have to be a choice of domain registrar in the market. I do not believe, in my understanding, that ICANN can control or influence that array of options. However, I do believe that the community here at ICANN has representatives from domain registrars, and so that could be a useful avenue for further collaboration and cooperation to working with these multiple stakeholders and figuring out what domain registrars can do. Given that more people are interested in privacy, more people are caring about privacy and willing to pay and have privacy of their information to make these options more accessible. I think having everyone here at the conference, including people who register domains and those who provide domain registration services, I think it could be a useful point of conversation as a jumping off point for future changes. So thank you for bringing that up.
Thank you. We have time for one quick question in the room.
Hi, my name's Elizabeth. I'm with CSRI, and I actually have a question for both of the researchers that were presented already. Has your research given any thought to the weaponization or the exploitation of the systems you're recommending towards vulnerable communities? We've seen DNS attacks hinder freedom of expression globally around the world for human rights defenders. We've also seen the way that police force, even in systems with strong rule of law, have exploited this to attack women and other vulnerable communities. And I was just interested if your research had looked at that dimension of this. Thank you.
Yes, thank you for the question. I completely agree, and that's something I've noticed in my research as well. I think in the line of my topic, definitely I think GDPR and other privacy legislation has required law enforcement and cybercrime investigators to jump through more hoops, I guess, in identifying the information. However, from what I have seen from my research and from speaking to people involved with law enforcement activities here at the ICANN conference this past week, they have the access to the data that they need to conduct their investigations. Only thing is they have to jump through more paperwork and hoops, like I said before, to get to it. And so I think the main concern is giving them timely access, letting their investigations proceed in a timely manner to identify these perpetrators of cybercrime and to stop them. I think that the changes that have happened already haven't hindered investigations to a huge extent. I think we just have to focus on streamlining this process and making that work in the future.